Patricia Van Haren, family law attorney. What do I need to know about the 20-20-20 rule and the 20-20-15 rule, and how do they impact my divorce? The 20-20-20 rule refers to a former spouse that meets the following three requirements. First, the spouse must have been married to the service member for at least 20 years. Second, the service member must have served in the military for at least 20 years. And third, the dates of marriage and the dates of service must overlap. So, for example, Bill enlists in the military in 1989, and he retires after 20 years of service. Well, Bill and Mary are married in 1991. They remained married for 25 years. And although Bill and Mary were married for 20 years, Bill was in the military for 2 years before the marriage and retired during the marriage. Therefore, Mary would not be considered a 20-20-20 spouse. In order to qualify to be a 20-20-20 spouse, Bill would have had to have served in the military for 20 years during the marriage. Therefore, if he had stayed in the service for 22 years, Mary would have qualified. The reason this is important is if the spouse qualifies for that 20-20-20 rule, then they will have accesses to the privileges for the commissary and the exchange and other base privileges for their entire lifetime. If they qualify under that rule, they would be able to receive TRICARE insurance, so long as they do not get remarried to anyone else before the age of 55. The spouse would also be entitled to direct payments from DFAS for retirement pay under the UFSPA as they meet the requirements under the 1010 rules as well. So then what is the 20-20-15 rule? A 20-20-15 spouse will meet the following three requirements. First, they're married for at least 20 years. The service member must have served in the military for at least 20 years. And the dates of the marriage and the service member must have been 15 years overlapping during the marriage. So going back to Mill and Barry, under that scenario, Mary would qualify as a 20-20-15 spouse because he was in the military for 20 years and 15 of those included a time that they were married. So under the 20-20-15 rule, the spouse will still be able to receive direct payments from retirement through DFAS. They would also be entitled to TRICARE for 1 year after the divorce is final, so as long as they're unmarried and don't marry anyone else. They would also be entitled to base privileges such as the commissary or the exchange for the duration of 1 year after the divorce is final. Understanding these rules can be tricky, so if you have any questions, shoot us over an email or give us a call.